Changes to the insolvency law to take the pressure off businesses, what are businesses facing as they open the doors, and bounce back loan fraud. All of this in this week's Business Finance Bulletin. As businesses get back to work, no doubt there are some that are feeling the pressure big time in terms of poor cash flow, reducing turnover, or in some cases no turnover for the last 3.5–4 months. Now those firms are obviously quite vulnerable in terms of creditor pressure. Now in previous bulletins I've mentioned that the government was putting together draft legislation to provide changes to the Insolvency Act which would take the pressure off those businesses. Well, that act has now been enacted into law as of June the 25th. This is the Corporate Insolvency and Governance Act. So what protection and support does it give? Well, first of all, one of the changes that are being put into place is that if a firm is going through a rescue plan or a restructure, creditors will now have to back off for a while. So there's a moratorium period before creditors can really start applying pressure. Also, if you're going through an insolvency process at the moment, suppliers have a right to terminate your supplies. Now the government obviously doesn't want that to happen, and so suppliers will now be prohibited from invoking any termination clauses, thereby ensuring continuation of supplies to allow the company to trade whilst the rescue plan is being put in place. Another change is a kind of temporary removal of wrongful trading. Now one aspect of wrongful trading is that if you knowingly enter into certain commitments such as debt obligations when you know you're insolvent, when under the previous regime you could be prosecuted for wrongful trading. Well, that ban has now been temporarily lifted, so it does give some support that businesses can take the right decisions in today's environment without fear of being prosecuted. And also the last major change is that creditors will now temporarily not be allowed to put in any statutory demands or file any winding up petitions as a result of coronavirus related debt. So it does give some kind of comfort and support for those businesses who need a bit of breathing space to plan ahead. Of course, this doesn't absolve you from the need to be taking proper advice. So if you are in this position, I would certainly encourage you to seek out support and advice from a licensed insolvency practitioner in your area. As businesses fling open their doors to start trading again, thankfully after a rather torrid 3 or 4 months, what are they being faced with? Well, that's a question that's been posed by the alternative finance provider MarketFinance. Now, they took a look particularly at the cash flow position of businesses. Now, rather worryingly, 90% of them say that they have invoices that are overdue that were issued in the beginning and middle of March. That's a long time to have money sat there, which is effectively uncollectible. Now, in total, the average amount outstanding comes to £149,000 per company. A big lump of cash not to have in your bank account just when you're trying to get trading again. Now, 81% of those businesses also said that going forward, they think it is going to be an even bigger challenge in terms of getting paid on time. Now, in terms of the cash flow position, matching the official statistics, the survey found that half of businesses that applied for CBILS loans were not successful. Now, and of those businesses that were successful, the average loan size was about £211,000. So we can see some businesses successful in getting cash and no doubt are feeling pretty comfortable about where they are in terms of cash flow, but nearly half of businesses have not been able to get hold of any extra cash, and of course that leaves them in a very precarious position when it comes to gearing back up again. So what can you do? Well, there's a couple of things you can do, either whether you did get cash from the CBILS or not. Going forward is all about managing cash flow, so plan ahead, do cash flow forecasts. Also take a look at your terms of trade. Do you really need to be perhaps as generous as you were in the past about giving 30, 60, 90-day terms? Can you bring that down in order to improve your cash flow? And as always, as I mentioned in the previous segment, make sure you are taking appropriate support and advice and have a sounding board in terms of the decisions that you are taking going forward. Approximately 950,000 businesses have now accessed the government loan support schemes, the bounce back loans and the CBILS loans. Now, as the weeks go by, more stories are coming out as to how businesses are using this cash, particularly bounce back loans. And if you've applied for a bounce back loan, you'll know that the process is very simple. Basically 6 or 7 questions to ask, it's all self-certified, and bang, you get the money up to a maximum of £50,000, up to also a maximum of 25% of your turnover. Now, however, because it's all self-certified, examples are coming out of kind of essentially fraudulent applications and fraudulent use of the money. Now, I want to have a look at this fraudulent use of the money. Now, the bounce back loan scheme is quite wide in terms of how you can use the money. Essentially, it's down to one of 3 things. You can use it for additional working capital, you can buy plant and equipment with it, or you can perhaps refinance a higher interest rate debt. You know my views on that if you've been watching previous videos. So those are 3 things you can use your bounce back money for. However, anecdotal evidence is now coming out that directors of limited companies are taking the money out and buying sports cars, putting them down as deposits against HP or asset finance facilities, and just taking the money out generally for personal use. The idea is, of course, the directors are saying, well, hey, I've got no personal guarantee against this. I'll probably ride this out for 6 months and then I'll put my company into administration, job done. However, they're not understanding there's a couple of things going on here. Number one, although you as a director are not personally liable for that debt under a personal guarantee, the company is still liable. So the banks will chase the company. Then you don't get away scot-free because the company is still liable. Now that means if an administrator goes in and has a look at your business, it's going to ask, hey, where's that 50 grand bounce back loan gone? And if they see that you've taken this money out yourself and used it personally, then they can prosecute you. Now, I mentioned in the first segment about a temporary moratorium on wrongful trading. Now, this does not cover this situation. You can still be prosecuted essentially for fraudulently using the money. So it doesn't get you off the hook. So make sure that you're using your bounce back loan for the right reasons: working capital, investment purchases, and perhaps refinancing our high interest rate debt. For another bulletin, as ever, I hope you enjoyed watching, and if you did, please don't forget to give it a like and a share. So that's it. Look forward to being with you next time. In the meantime, have a great, successful and profitable week.